So hopefully everyone can now see my slides and can hear me. Let me know if you can't. So I'll take that as a yes. So I'm going to give my perspective for the next 15 minutes on the challenges that we'll face with the new regulation, and I'll try as well, like Cristina, to give an overview of what I think are the most significant innovations. I'm afraid I think I've been a little bit more negative than Cristina has been, although equally I recognise that there are a lot of positives in the regulation, but maybe I take a slightly different perspective. But I think in some ways, while it's easy for us in universities to stand in criticism, I think that's also part of our job to identify the problems in instruments like these. So my first point, and I think I'm echoing Cristina here, this is a really long regulation, and in preparing for this seminar I was reminded of that. I read all of the recitals again, and just by way of metrics, the old Brussels II bis regulation took up 29 pages in the official journal. This new regulation takes up 115 pages, so it's almost 3 times longer. And I think crucially, one of the big changes is in the structure of the regulation, because of the way the child abduction provisions have been moved about. So I think, for example, with the new recast of the Brussels I regulation, I think anyone who was familiar with the predecessor would have little difficulty in navigating the new regulation, whereas I don't think that's the case with the new version of the Brussels II bis regulation, or Brussels IIter as we're calling it. There's a huge number of amendments. As Cristina said, it is in a sense quite a conservative regulation. They're mostly smallish amendments, but nonetheless huge numbers of them. And many of the de facto amendments are in the recitals rather than in the operative provisions. And there's a huge number of recitals. And I think judges won't be able to ignore these recitals, because they're not just general statements of aspiration or principle. A lot of them set out very specific courses of action that judges are expected to take. And a lot of the provisions or the sort of themes are very much scattered amongst the recitals. So I think there'll be a challenge in matching up the particular recitals with the relevant operative provisions. Now, the fact that it is so detailed and complex, in one way it's a positive. So you have all of this granular detail, which in some ways is great. For example, you have provisions linking up child abduction and domestic violence, and carving out exceptions for ADR, for the domestic violence context, and carving out an exception for sharing addresses and so on for the domestic violence context. So in some ways, all of this detail is wonderful, because it's very clear to judges when they should depart from the general principle. But I think there is a sense that you're drowning in detail, especially when you're navigating all of the recitals, which don't seem to be organised in any very coherent way. I think a practice guide will be vital here in matching up all of these provisions. And in some ways, when I was reading the regulation, I thought perhaps maybe some of that detail that's in the recitals might have been better included in a practice guide, so left out of the regulation itself and included in a practice guide. And I would really have concern that busy lawyers and judges will really struggle to make sense of this regulation and to apply it correctly, because we've already seen from the Court of Justice case law on the Brussels II bis regulation that lawyers and judges already struggle to some extent with that much simpler framework. And I think they will struggle a lot more with the new regulation. And I think this is particularly a concern because the proposal for concentration of jurisdiction has been moved to the recitals. It's not in the operative provisions. So you won't just have specialist judges applying this regulation, and we probably have to expect that there will be many judges applying this regulation that will not be routineers of cross-border family law. And I noted there, I was amused to note that in recital 3, there's this aspiration that access to justice will be simplified. And whatever the merits of the regulation, and there are many merits, I don't think simplification is an objective that is achieved here. Another challenge that we'll face in 2022 and over the decade is the non-reform of divorce jurisdiction. So the next review will be in 2032, according to Article 101 of the new regulation. And so we'll be stuck with the divorce jurisdiction rules that were agreed back in 1998 in the Brussels II Convention until 2032 at least. And of course, we did have high hopes for new provisions on party autonomy, on forum necessitatis, on the reform of residual jurisdiction. I know anyone who's had to explain Article 6 and 7 to students will appreciate how complex those provisions are. And also there were hopes for a provision based on the Brussels I recast, allowing courts to stay proceedings where there are earlier third country proceedings. So there are all sorts of problems with the existing jurisdictional scheme, and none of those problems are going to be fixed for now. And in the EU Commission impact assessment, it seems that the failure to reform divorce jurisdiction resulted from political disagreement on coverage of same-sex marriage. So that seemed to make the reform of the matrimonial provisions an impossibility. So that's, I think, going to be a challenge over the next 10 years as divorce law and cross-border family law more generally moves further and further away from where it was back in 1998. We're stuck with these provisions which are now really out of date. And I think particularly the lack of provision for party autonomy is a problem, because all of the other instruments like the maintenance regulation, for example, do provide for party autonomy, but this regulation is out of step. Now, having said that, so in 2016 we were given to understand that reform of the matrimonial provisions would be impossible, but in the end it seems that it was possible to introduce at least some reforms. And one thing that strikes you when you look at the Article 1 provision on the scope of the regulation as respects matrimonial provisions, you immediately notice a change in the wording here in Article 1. In the old regulation, we were told that the regulation shall apply whatever the nature of the court or tribunal in civil matters relating to divorce, legal separation and annulment. Those words in red on the left of your screen have disappeared in Article 1 of the new regulation. So we're now told the regulation applies in civil matters relating to divorce, legal separation and annulment. So there is no requirement in the new regulation that the divorce have been obtained from a court or tribunal. And I think this is really significant because the existing regulation was very unclear on the status of non-court divorces, which, as you'll all know, are becoming increasingly common throughout the EU. More and more member states are allowing for divorce without recourse to a judge. And there were very contradictory indications on this in the old regulation. You have the Article 1 provision on scope, which suggested there must be a court or tribunal, but then you had Article 46, which appeared to suggest that private agreements are enforceable. And then you have the Sayuni judgment, which was on Rome 3, but also spoke about the Brussels II bis regulation and suggested Brussels II bis only applied to divorces pronounced either by a national court or by or under the supervision of a public authority. So a conception of divorce practice which didn't match that well with the emerging practice in member states. So I think the new regulation will provide a lot more certainty for those divorces which are obtained in member states and not from a court. And Cristina has already touched on these provisions on recognition, cross-border recognition of agreements and authentic instruments. So we're now told in the provisions following Article 64 that a divorce concluded by agreement of the parties and registered with a public authority, or a divorce evidenced by an authentic instrument and established by a public authority or an authority empowered by that for that purpose, can be recognised in other member states. But there must be a certificate. Now, Christina's already mentioned this, but it's very clear from the regulation that if there's no certificate, then there's no circulation for the divorce. And this certificate has to confirm that the divorce is binding in the member state of origin, but crucially also that the member state of origin had jurisdiction. So this presents a picture of verification of jurisdiction after the event. And I think that may create some problems, because I think you're likely to end up with a situation where divorces will be obtained, and then later on there will be a check on divorce jurisdiction. It'll turn out that the divorce jurisdiction rules weren't complied with, and then no certificate can be issued. So you may end up with this growing category of member state divorces which don't enjoy free circulation throughout the EU. And in a way that would be a step backwards, because up until recently at least, when this uncertainty around non-court divorces has crept in, but say up until 5-10 years ago, you could say with certainty that if a divorce was granted in a member state, it was entitled to recognition in all of the other member states, no questions asked. There's also a question as to whether other member states may be able to conduct an element of jurisdictional review. If you look at Article 69 of the new regulation, it includes the usual prohibition of the use of public policy for jurisdictional review. But it only refers to the public policy defences for decisions. It doesn't refer to the public policy defence for agreements. So there may be a suggestion there that, for example, where a French non-court divorce was obtained by a German couple, that the German authorities may be able to conduct jurisdictional review in those circumstances. Another subtle but maybe significant change relates to the language in reference to spouses. Now, both the old and the new regulation in the operative provisions use the gender neutral language of spouses, but the old regulation uses the language of husband and wife in the annex, whereas the new regulation doesn't. So the new regulation is entirely gender neutral in a way that the old regulation wasn't. Plus we have the Coman judgment, which in certain parts of the judgment appears to suggest perhaps that there may be a wider obligation to interpret spouses as including same-sex spouses for the purposes of EU legislation. So the combined effect, I think, of Coman and this change of language in the Brussels IIter regulation may be that we can now assume that spouses include same-sex spouses. Now that's by no means crystal clear. There are arguments to the contrary, for example, the principle of continuity in recital 90. But there are certainly stronger arguments to be made to that effect now than there were previously. In terms of other challenges that we face, one challenge is enforcement of return orders. And it's often occurred to me reading, for example, the case law of the European Court of Human Rights, that there seem to be many cases where the left behind parent easily obtains a return order, and then that return order is never enforced. So it often seems that enforcement is where the system breaks down. And I thought it would be a very positive thing if this new regulation tackles that issue of non-enforcement, because it's something that isn't really particularly addressed by the Hague Child Abduction Convention itself. And I was glad, therefore, to see this new provision on expeditious enforcement of return orders in Article 28 of the new regulation. Now, the wording isn't particularly strong, particularly if, for example, you compare it with the wording of Article 24. But I still think this is really significant because it will enable the Court of Justice to build on enforcement obligations, something that they wouldn't have been able to do before. So it'll give the court a hook to hang a new development in its jurisprudence on. This is something that the Court of Human Rights has already been working on, and I think it'll be a really positive innovation if the Court of Justice can join forces with the Court of Human Rights and really beef up the enforcement of return orders. Another challenge, I think, at a very general level is the building of mutual trust. So again, in the new regulation, we see references to this ideology of mutual trust. But whilst this in some ways is presented as a legal principle, I think it's arguable that trust really isn't a legal construct at all. It's something that can't be ordained by law. And I think the challenge is really to move from this aspiration and to turn it into a reality. So for that reason, I was really glad to see Article 86 on direct judicial cooperation, which Cristina has already outlined. And I think that may be, so giving more prominence to judicial cooperation, and as Cristina said, in a general way, not just in one narrow context. I think this may be a very useful step forward in building real mutual trust, where judges get to know each other and cooperate more directly with one another. In that context, though, I was disappointed to see that the concentration of jurisdiction left out of the operative provisions, because I think if you had that system of specialist judges, a small number of judges in the EU dealing with this regulation, I think that would really bolster mutual trust if it was the same people all the time. I do wonder as well about the new provisions providing in effect a sort of a veto on the veto. So as you all know, under the existing regulation, where a requested state issues a non-return order on grounds of grave risk, for example, the Court of Origin can override or veto that non-return order. And the new regulation in Article 56 appears to allow the requested state then to override the override or veto the veto. Now, this is framed in very narrow terms, but I do wonder what this will do for mutual trust. And my sense is that this won't do much to enhance mutual trust. And I do wonder sometimes whether it might be better simply to stick to the original Hague Convention procedure. So simply a request for return, and if there's a non-return order, then that's that. Because in a sense, if all of the member states really do trust each other, then surely that should be sufficient. And certainly some of the literature suggests that the veto system really hasn't worked. So I'm not sure whether adding a new layer to that veto system really does anything for mutual trust. I think I'm running out of time, so just very quickly then, I'll just highlight another couple of points. Anyone who has worked in this area of abduction will know also that the endless appeals are a real problem. So the abducting parent endlessly appealing in the requested state to avoid return. And in that context, I would agree that that is a real problem. And in that context, I was again disappointed to see that the proposal to limit the parties to one appeal had been moved out of the operative provisions and into the recitals. I also would be somewhat concerned that the new provisions on ADR might also encourage delay. I can see the positives here that Cristina has already highlighted, but this might, so looking at this cynically, an abducting parent might see this as another opportunity to drag things out, to agree to participate in mediation with no intention of really actually signing up to any return arrangement. Then finally, a few other points. So one positive, I think that the prose in the new regulation is much, much cleaner, much, much tidier. So whilst judges and practitioners may be drowning in detail, I think the way in which the regulation is written is much superior to the old regulation. And also, there's been a lot of tidying up of little anomalies, which again is a real positive. So, for example, in recital 48, you have this duty to state the ground for non-return, which is a small thing, but the whole veto mechanism assumes that the ground for non-return is stated, whereas previously there was no specific obligation to do that. Also, I think the abolition of the declaration of enforceability must surely be a positive development, which will hopefully lead to quicker, cheaper enforcement. And also, again, another couple of positives. I think the new regulation is much better in its alignment with international instruments. For example, the wording of the right to be heard. Previously, under Article 11 of the Brussels IIter regulation, age and maturity were presented as eligibility factors, when in fact, under the Convention on the Rights of the Child, they're simply weight factors. They affect the weight to be given to the child's view. So I think it's really positive that Article 21 is now entirely in line with the Convention on the Rights of the Child. And also the disconnection clause for the 1996 Hague Convention is now much improved, and it fits properly with member state obligations under the 1996 Hague Convention in a way that the disconnection clause in the old regulation didn't. So there are lots of little things like that which are really, really positive, and which will make the judge's life, I think, much easier. The fact that the disconnection clause makes sense. So I'll leave it at that, and I'll stop sharing my screen and hand over to Michael. Thank you very much.